Hello everyone, my name is Priya. I have completed my graduation BBLLB from Mahatma Gandhi Law College, Usman University, and I have been admitted into Nalsar for my post graduation, which is LLM, for academic year 2024-2025, and I have been enrolled as an advocate in Bar Association, Telangana, Telangana State Bar Association, and I'll be taking your constitution law series, fundamental rights as well as fundamental duties. So in today's class, we'll be discussing about Article 21 and Article 21A. Article 21 talks about protection of life and personal liberty, whereas Article 21A, which have been newly inserted via amendment, it talks about right to education. Protection of life and personal liberty. So Article 21 declares that no person as in both, person here means both citizen of India as well as non-citizens, that means NRI or foreign citizen, everyone, that no person shall be deprived of his life or personal liberty except according to the procedure established by law. So actually, this Article 21 is inspired by American laws, American Constitution. So here, procedure established by law is our legislative rules, laws, acts. So what they want to say, Article 21 says that no person shall be deprived. In a sense, everyone should have right of life and right of personal liberty. No person should be unaware of it. And here, in person's definition, we mean Indian citizens as well as non-citizens, which means foreign nationals or NRIs, non-residents of India. So Article 21, uh, like, it has various meanings, and it have been expanded or changed time to time according to the judgments, landmark judgments given by Supreme Court. So in this lecture, we'll be covering two main landmark judgments. First one is of A.K. Gopalan versus State of Madras, and later on we'll be seeing Maneka Gandhi versus Union of India. So here in A.K. Gopalan versus State of Madras, Supreme Court have took a narrower interpretation of Article 21. You mean by narrow, right? So narrow is like they have blindly focused on what law is saying. They didn't implement it, in a sense, in our law. What we say, we should see spirit of law, not word of law. But in this judgment, A.K. Gopalan, our Supreme Court has focused only on word of law, not on the spirit of law. What it means is they have just understood same as it is what is written in law, and they haven't applied their, in a sense, they haven't applied what spirit of law is saying. So in this famous case, Gopalan, this person was an opposition party, and he was held, in a sense, he was arrested under preventive detention act. What do you mean by preventive detention act? In a sense, whenever police officers or any intelligence department feel that this person might cause any harm, this person might commit any crime or commit any offense, at that time they have right to arrest that person under preventive detention act. So this person was an opposition party, okay? So he was held arbitrarily. What even arbitrarily? In a sense, arbitrary is something like wrong or falseful thing, that is known as arbitrary. So he have filed a writ in Supreme Court saying that laws are misused and I have been held by police arbitrarily until something like unlawfully or with a wrong motive. So here what Supreme Court said, we'll be seeing here, it held that protection under Article 21 is available only against executive action and not from arbitrary legislation. This is what Supreme Court said. Supreme Court said that under Article 21, what they said that they said if the person, the police officer, is following laws and rules wrongly, or else he's not complying with laws, at that time only we can give Article 21, we can take it in scope. If they are following rules, laws correctly, we can't give you this relief. But here they didn't focused on wrong legislative action. They only focused on execution. If it means if law is wrong, they can't do anything, because whatever is written in law, they'll do that thing, but they'll not go against it. This means the state can deprive the right of a life and personal liberty of a person based on law. If in law it is written that, for example, in emergency, you don't know, right? No one has right to question, even if they are getting arrested. In a sense, this is breach of Article 21. But still, state can't do anything, because when while emergency, our fundamental rights are not in power. This is what Supreme Court said. That Supreme Court said, if this thing is written in law, we will not do anything. If arbit execution is wrong, then only we can take any step. This is because of expression procedure established by law. We have seen here, right? Every person has right to life and personal liberty, except when according to the procedure established by law. If in law it is written that okay, you can arrest, then even state has no power to go against it, which is just which is different from the due process of law contained in American Constitution. In American Constitution, they say due process of law, in a sense, according to the process of law. But here in our Indian, in this judgment, they focused on the procedure established by law. According to our Article 21, they say whatever is written in law will follow the same. And our Supreme Court gave the judgment on basis of this, stating that in law, if it is written, we can't help you, we can't do anything. Hence, the validity of law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. They are saying if it is written in law, you can't question that the wrong is, this particular law is wrong, it is unreasonable, unfair, unjust. You can't question that. Secondly, the Supreme Court held that the personal liberty is only restricted to the person's body, individual person's body, or something related to its body. In essence, if I am a person, something related to me or my body is only considered as personal liberty. This was given as an explanation of this article. They explained Article 21 is all about a person, his liberty, or something related to his body of individual. That's it. But in Maneka Gandhi case, they took from A.K. Gopalan to Maneka Gandhi. What changes happened is, in Maneka Gandhi, they saw the wider path. They consisted Article 21 right to life in a broad way. In a sense, they included many other things as well. In Maneka Gandhi case, the Supreme Court overruled its judgment, which was given already in whatever judgment it given in 1950 in case of A.K. Gopalan. It was overruled. Hopefully, you know what is overruled. Overruled, in a sense, they have surpassed its own judgment. They said this judgment is not right, and they gave a new, fresh judgment which was opposing to it. In Maneka Gandhi case 1978, Supreme Court said that it took a wider interpretation, because here in A.K. Gopalan they took a narrow and here they have said that right to life and personal liberty of a person can only be deprived when the law itself is reasonable, fair, and just. So, in other words, what they are saying that you can like restrict that person's right of life and right of personal liberty. What do you mean personal liberty? To move freely, to travel anywhere they want. So if someone arrests you, if a police person arrests you, they are breaching your right to life and personal liberty. Okay, they are breaching your personal liberty here, and they can only do that, they can only restrict you from this right when the law itself is just, reasonable, and fair. In other words, they have introduced this American expression, that is due process of law. If law is right, reasonable, then only you can restrict the right of particular individual. Again, letting you remember, in Article 21, individual consists of both Indian citizen as well as foreign citizen. In effect, the protection under Article 21 should be available not only against the arbitrary execution. Arbitrary execution is what, when police officers wantedly or in a falsely, uh, in a fake case, they try arrest you, or try false imprisonment. What do you mean by false imprisonment? In a sense, you didn't did anything wrong, but still they lock you in a room or in a jail or in a area where you can't move freely. So in this point, they are saying that under Article 21, we have protection against false, that is arbitrary execution, as well as against arbitrary legislation action. What is legislation action? Uh, Legislation makes law. Legislation is parliament. Parliament makes law. So even if our laws are arbitrary, in a sense, unreasonable or unlawful, even then we get protection under Article 21. Further, the court held that right to life is embodied in Article 21, which is not merely relating to the existence of a human being or survival, but it also exists to right to live with human dignity, that is, right to dignity and all the aspects of life, which goes to make a man's life meaningful, complete, and worth living. So here, like years on years, Supreme Court have given n numbers of judgments, like which broadens our definition of Article 21. They have included right to health, right to travel, right to adopt, and like anything which makes a human being's life meaningful will be covered under Article 21. That is, it is considered as right to life. It also ruled the expression personal liberty in Article 21 is also widest amplitude, and it covers a variety of rights that go on to constitute the personal liberties of man. So here, later on, the personal liberty, the word personal liberty is also widened, and here they have included various varieties of right under personal liberty. The Supreme Court has reaffirmed its judgment in Maneka Gandhi case. It have reconsidered its past judgments in subsequent cases, whatever it gave, and it said, and it declared as these following rights are part of Article 21. What are those extra rights which have they considered as Article 21? Under Article 21 are right to live with human dignity. Other one is a human being has right to decent environment surrounding him, and which includes pollution free water, air, protection against hazardous industries. That's the reason we don't have any industries or factories around the place where people live. It will be in outskirts or in remote areas, but not around people where the people live. So this is the reason, because every citizen or every individual has right to decent environment, right to livelihood. So what do you mean by right to livelihood? In a sense, they have right to earn, get a livelihood, right to privacy. This is Aadhaar card case. Hopefully, you know what is right to privacy Aadhaar card case. Please ping in, or else like answer it in comment box. What was the landmark case? It is also known as Aadhaar card case, which is right to privacy. If you know the landmark case, it is like bit recent. It's not that old, so you can answer it in comment box. Right to shelter is also a right which is covered under Article 21, and right to health. These all are inserted as they have widened our Article 19's meaning. Now we have come to Article 21, which is right to education, and it have been inserted through 86th Constitution Amendment. Via 86th Constitution Amendment, we have inserted it in fundamental right as well as in fundamental duties. Before it, it was only a DPSP. What it is like directive principle, state policy, which is not effective by law. We'll be seeing it in later classes. What is DPSP? What are fundamental duties? So DPSP is something which when a legislature, in a sense, when Parliament is making law, they'll consider DPSP, but it's not. It is not a compulsion to take that particular thing into effect. So in 86th Constitutional Amendment Act, Article 21 was been inserted. What Article 21 says is that state shall provide free and compulsory education to all the children from the age of 6 to 14, that is basic elementary school, what you say, first to 10th, like that. And in such manner, state may determine that this provision is only made for elementary education, that is 1 to 10th, and not for the professional educations or higher educations. This is a fundamental right under 21. Because of it, and this thing was enacted in 2002, but it came into effect in 2010. So like how slow India is going on. So at that time they said like this will be only the free education will be only for children who are from 6 years old to 14 years old, and it will be only elementary education, not a what you say, professional education. This amendment is a major milestone in the country's aim to achieve education for all. This came with the motive that every person, every child has right to education, and this is considered as a major milestone. The government described this step as a dawn of the second revolution in the chapter of Indian citizen. This is the kind of a dawn or like main center of attraction in second revolution for Indian citizens. Then even before this amendment, the constitution contained it. It was actually a part of Article 45 in Part 4. Before this amendment, the constitution contained a provision for free and compulsory education for children under Article 45 in Part 4. That was a fundamental duty. However, being directive principle under Article 45, that is our DPSP, sorry. So under DPSP, it could not be enforced because it is not a compulsion to consider it. They'll only see it as a reference. DPSPs, that is directive principles, state policies, are only used as reference when parliament or like our state legislators are making laws or rules. There is a scope of judicial intervention in this regard. This amendment changed the subject of matter of Article 45 in directive principles, and it now reads that states shall endeavor to protect early childhood care education for all until they complete the age of 6 years. So here before it was like right to like provision of free and compulsory education was first in Article 45. Now they have inserted or like changed it in a different way. Now that DPSP is known as the state shall endeavor to provide early childhood care and education for all children until their age of 6, in a sense, like Anganwadi. If the child is small, they send sattu, what say, millet, eggs. That is like early childhood care. Later on, once they turn 6, they'll open Anganwadis and all. They'll have free schools. These all are under these schemes under this DPSP. It also added a new fundamental duty under Article 51A that reads, it shall be the duty of every citizen of India to provide opportunities for education to his child or ward between the age of 6 and 14. So in between 6 to 14, every parent or every guardian has duty to send their child to school to give them or provide them education. This have been inserted in fundamental duty. In 1993 itself, the Supreme Court recognized a fundamental right to primary education in right to life under Article 21. In 1993, they have said, but it held that every child or citizen, it held that every child or every citizen of this country has right to free education until he completes the age of 14 years. So if a child is below 14 years old, they have every right to get a free education. Thereafter, this right to educate is subject, and they said that it is only subject to the economical capacity and development of the state. If it is according to the state and even according to the child, if he is poor or like rich, according to that. In this judgment, the court overruled its earlier judgment of 1992, which declares that it was a fundamental right to education up to any level, that too including professional education like MBBS, LLB, engineering, these things. So it have overruled 1992's judgment. They have overruled in 1993, and they say the fundamental right of free education is only up to the age of 14 years old, which is elementary education, basic one, 1 to 10th. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009. So this is RTE Act 2009. The act seeks to provide that every children has right to be a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfy certain essential norm and standard. That is like our Zilla Parshids, if you know. Those are government schools, and every person should go through this full-time elementary school, and they should have quality norms and standards. They should have good quality education. This is what RTE Act focus on. This legislation is anchored in belief that the values of equality, social justice, and democracy and creation of just and human society can be achieved. Because once a citizen is educated, the difference between rich and poor comes on decreasing. Because if that person is educated, he can be employed, he can start earning, and his livelihood automatically gets improved. So here, uh, this particular legislation brings the value of equality, because rich people's children will be going to school, even they'll be going to school. There's social justice. It is a kind of social justice, because right to education is everyone's fundamental right. Now they are creating humane society where everyone will be educated and employed. So only through this provision of inclusive elementary education to all. So through this compulsory elementary education, they will achieve these goals and values. The act came into effect in 2010, 1st April. Huge discounts are going on. Mega mock test for AP and Telangana LAWCET 2024. Link is in description box. You can just ping in WhatsApp or Instagram.